And let's see. I have this telephone conference at 10:30, but if we can get it done before then on Tuesday.
All right, so it'll be first up on Tuesday at 9:30.
Okay.
That works for you, okay, Mr. Jackson?
Yes, it does. Thank you so much.
All right, so Tuesday, the 29th, at 9:30 a.m. I'm going to push it in. This will be the first thing I call. Again, for the record, this is the subjects. This is case number 21-14076, striking 786. It's set on for a ruling on a motion for summary disposition. The court did not receive, although Mr. Ashley filed his response to the defendant's response to the motion for summary, to the plaintiff's response to the motion for summary disposition. The court has not received it, would like the benefit of being able to read that. Mr. Ashley is going to email it over, and then we set that for 10 a.m. I'll strike at 9:30 a.m. on Tuesday the 29th. Have you said it yet, Mr. Ashley?
Yes.
So it hasn't populated here, so let's just go through the email address one more time just to make sure that we're getting it. And that's LATIFH.Hunter.
Oh, wait, is it? I'm sorry. Is it FH or FAH?
LATIFAH.
Okay.
.Hunter. At 3636PH District Court.
Okay, I think I might have messed up. Let me send it again.
Mr. Ash, I see your email address at the city of Detroit. So if for some reason I don't get that shortly, I'm going to have somebody email you and tell you you didn't get it. So
Okay.
right.
Should go through right now. Let's see. Oh, wait a minute. Hold on.
All right, so I'm gonna move, but I gotta get to some other hearings. What I'm gonna have her to do, I'm gonna have her to send you an email right now, just hi.
Okay.
Send it back to that, Mr. Ashton.
Oh, this is JP, oh,
That one.
this ain't Alfred. I don't think we see it.
That's it. I guess so.
Yours is Alfreda at Detroit.
It's Alfred A at DetroitMI.gov.
She made it Alfreda.
Alfred. Well, it worked out. All right, okay.
You know, when I first looked at it, I immediately saw Alfred, then I handed it over to her. She says Alfreda.
Alfred, okay.
All right, she's gotta send you an email right now, just so that you can send it back under that, and you should be all set.
Okay.
Okay. Thank you, Your Honor.
All right. We'll see you guys on Tuesday.
Thank you.
Thank you, Mr. Jackson. All right, this is case number. Case number 21-240913. This is Carolyn Parnell versus Sheila Lucas. That is before the court, set on for a the hearing on today's, it looks like there is a motion for reconsideration. The case was previously for. All right, let's see. Do I have Carolyn Parnell on this Zoom? Say something if you're here.
He's on mute.
Ms. Parnell, it looks like I see you there. You will have to unmute your device, ma'am. Hit *6, that should unmute for you.
Okay, is it unmuted?
Yes, ma'am. Good morning to you. What is your name?
Carolyn Parnell?
All right, thank you, Ms. Parnell, and good morning again. So you apparently you filed a motion asking that the court would reconsider and set aside the dismissal of this case. Is that correct, ma'am?
Yes.
All right, so do I have someone here for Sheila Lucas? Sheila Lucas, please. Sheila Lucas. All right, calling for a person who purportedly lives on Hazelwood Street in the city of Detroit. This matter came before the court relative to a case that was before the small claims division of this court. The case was called at 11 a.m. Plaintiff, it says, appeared, defendant did not appear. It says service is good. Then it says the case is dismissed without prejudice. That was back in November 2021. Subsequent to that time, just one moment, just looking at and subsequent to that time, it said, well, I see one of the issues here, there was no certificate of compliance. And then I received then there was a motion for reinstatement indicating that certificate of compliance was pending. And subsequent to that time, I received another motion. Says when subsequently obtained certificate of compliance since dismissal, certificate of compliance was not in place when case originally heard. All right. So, ma'am, so apparently this is something you're suing regarding residential property, and when you came to court, they dismissed it because you didn't have the certificate of compliance. Is that correct?
Yes.
All right. And that was in the small claims division, and you're appealing the dismissal. That's not really the way to do this. You have to start that case over because that was a small claims case. If you have what you believe to be a cause of action against the other side, the opposing party in this matter, you will need to start a new action, and in that new action, you will need to allege the same things you alleged before, but further allege that you now have a certificate of occupancy and that it covers a period that is relevant for considerations of this case. As a small claims case, this is not small claims court unless you are appealing a dismissal. Your appeal of that dismissal, you have no basis to appeal it because you didn't have a certificate at the time the case was dismissed. You can file another case, and that is your remedy. You have to file another case. All right. So I'm denying the motion to set aside dismissal, but you have the right to start a new case if you wish to, and that's what you have to do.
But a question, sir. If I start a new case, will a certificate of compliance still be a factor?
It will likely be a factor, but at least you have a proper standing to file it now because you have the certificate. So I mean, you have to address those issues as you come to them. You also, you can either file your case in small claims, or you can file it as a general civil case. But yeah, the certificate of occupancy is going to be, it's a predicate before you can actually bring the case to court. But if there was no certificate of occupancy at the time of the rental, that's gonna come up in the case somewhere. But I mean, you gotta cross first things first, I suppose.
Okay, so that'd still be an issue of if I didn't have it at the time that the person rented the property.
Absolutely, absolutely. Now, is that an issue that will prevent you from getting any recovery? I'm not sure. Someone, perhaps myself or whoever the case comes in front of, will have to look at everything that's involved. That certificate of occupancy is going to be a crucial issue. Now, let me ask you something as I have to move on to another case. So, did you receive some funds from under the CR program?
No, I did not. I didn't receive anything. And
Okay.
in addition to the rent, she had agreed to pay, but then she moved out, but then she also damaged my property.
Yeah,
Eh.
yeah. Yeah, so I mean, you still have the right to litigate those issues. The only reason I asked you that question is because some of these cases are involving a situation where CIRA agreed to pay X amount and they held back a portion of it because there was no certificate, and then there was a certificate of paid the rest. That's why I was asking. I thought it was one of those cases, but yours is a little bit more complicated than one of those situations. But that doesn't mean that you don't have the right to recover something. You just have to, you have to start fresh. You have to present a certificate, and then you have to, when the issue comes up, if the person in fact shows up, if the issue comes up, then you will want to raise what the conditions were at the time the person moved in and what the conditions became subsequent to that time, to show that whatever was might have been the problems that you stood ready and able to correct, or that this person made the problem worse. Those are seems to be the issues that you raised. All right. I wish you well, ma'am. Good day to you. All right, this is case number 21-240-990. This is Jeffrey Bookrum versus Carl Moore. Matter is before the court on the following the complaint. It looks like this started in the small claims division and was removed to this court. And I do see that there is an answer filed in this matter as well. Your appearance for the plaintiff in this matter, please, or plaintiff, if you're here, whoever is here on the plaintiff.
Good morning, Your Honor. Attorney Scott Colossus, attorney of record Jack Jaffe on behalf of the defendant Carl E. Moore Sr.
Thank you, sir. Although you called out and you answered out of line, I'm looking for the plaintiff first, but
Oh, I apologize.
that's not a problem. Look like they may not be here, Mr. Colossus, is it? Did I say
Yep.
it right?
That's
correct. So let me call again. Bookrum, Jeffrey Bookrum, if you are here, please say something. All right. The record should reflect the court did send out a notice in this matter on January 21st, directing that the respective parties would appear for the hearing on today's date. I'm seeing a little bit of confusion. Was on our notice to Mr. Moore. Well, let's see what's going on. Oh no, I don't see any confusion. All right, I see where our notice to Mr. Bookrum is at the address that he provided to the court at the time that he filed his complaint, and that is an address in Port Huron. Court's notice went to that address with this date and with the Zoom number for the defendant, that's right, for the plaintiff to be here at this time. Plaintiff has not appeared on this matter. And the matter was set on for 9:45. Again, it's now 10:24. For that reason, it looks like I do see a counterclaim in this matter. At least as it relates to the plaintiff's case, it seems to me that it would be dismissed where the claimant did not appear. Counsel, anything else? Anything you want to say?
Yes, Your Honor, as you stated, Mr. Bookrum has failed to appear, and I would ask for dismissal of his original claim. And for the reason that he has failed to appear and the fact that he hasn't answered our counterclaim, I would ask for an entry of default and default judgment for the amount requested in the complaint.
All right, now, have you spoken with the plaintiff in this matter at all? Have you had any contact?
So, Your Honor, what happened was we did file our answer and counterclaim with the court back in November 12th, and it seems that that filing didn't go through officially, and so we refiled it on January 11th and everything. And both times we sent it to that Port Huron address by first-class mail, but no, we have not heard from him at all.
All right, I've reviewed the counterclaim in this matter. And the counterclaim sounds in a breach of contract and damage to premises. It sounds like the defendants, right, the plaintiff in this matter was suing, it appears to recover a security deposit to cover some amount we believe was owed to you. It has not appeared regarding this matter. Again, the complaint will be dismissed, given that the counterclaim seems to be related to the dispute that was raised herein. I will grant default on the counterclaim and will allow for entry of judgment. So, counsel, you may submit a proposed judgment to the court. After the expiration of 14 days, the court will enter the order unless I receive something indicating that I should do something to the contrary. So you can submit that proposed order to the, you can submit it by way of email, or you can mail it to the court. Let me give you the email address. That's Latifah, LATIFAH .Hunter @36districtcourt.org.
Thank you, Your Honor.
All right, thank you, counsel. Good day.
You have a good day as well.
The court now calls case number 21-166-458. This is Biomolecular Integrations Incorporated versus Auto Owners Insurance Company. The matter is before the court. Looks like set on for a motion on a motion for summary disposition. Your appearance at this time, please.
Good morning, Your Honor. Richard Brewer, P31124 on behalf of plaintiff.
All right, thank you, Mr. Brewer. Good morning to you, sir. For the defendant in this matter, please. I have someone for auto owners. Is that Ms. Vidala? Counsel, you spoke to anybody on this today?
Judge, this is a strange situation. I've never received responsive pleadings from the defendant. I see from the Register of Actions that they filed a motion for summary disposition, but apparently not an answer. I never received the motion for summary disposition. And I have no information as to a defense lawyer to reach out to. It's not on the register of actions. It's not on the notice of hearing. And as I say, I've never received responsive pleadings.
All right, got you. Let's see what I have. Now,
Judge, I'm here on the bio hunter matter. I'm just
Okay, there's defense
between two
counsel.
courtrooms. Can you give me like 2 minutes?
yeah. Come on.
Thank you.
Yeah, we got you.
Sorry about that, Judge.
Not a problem. Just one moment.
So yes, I'm here for Progressive on bio hunter.
Yeah, give me one second.
Okay. Sorry, I saw Mr. Brewer talking. I didn't know if the case was called.
Yeah, it has been called and he was talking, but we'll start fresh in just a moment.
Okay, I'm so sorry about that.
That's not a problem. All right, so we're back on the record with regard to Biomolecular Integrations Incorporated versus Auto Owners Insurance Company and Jimmy Hunter as third-party defendant in this matter. Mr. Brewer has previously entered his appearance regarding this matter for the plaintiff. Your appearance for defendant or defendants, Madam Counsel.
Yes, Your Honor. Nancy Goodall on behalf of auto owners in this matter.
All right, thank you, Counsel. And so, Mr. Brewer, you were saying that you did not receive the plaintiff's strike debt defendant's answer, nor have you received a copy of the motion for summary disposition in regard to this matter.
That's correct, Your Honor. I have a strong suspicion that I know what the motions would be about. There's two possible bases. The bottom line is this. I had originally represented Mr. Hunter. I do not represent Mr. Hunter as a defendant in this case, or as a third-party defendant in this case. But I had previously represented Mr. Hunter and settled his PIP claim, wherein he waived future benefits. Now, therefore, I agree that this matter should be dismissed because the claims being made in this case were in fact dealt with in the prior case, the circuit court case, wherein he settled and waived future benefits. But I can't speak for Mr. Hunter in this case because I don't represent it.
And so, well, let's kind of get this on track here. And I'm going to go to Ms. Galala to help me do that. Go ahead, Madam Counsel.
Yes, Judge. So Mr. Brewer did represent Mr. Hunter in his other suit, wherein, as Mr. Brewer indicated, Mr. Hunter released any future benefits, all past, present, and future medical expenses, which would encompass this exact bill for provider plaintiff. It was the same firm that was represented, so there was no notice requirement. I mean, Mr. Brewer and his firm were on notice that this claim was settled. We're asking for a dismissal based on that. I mean, there's really no question of fact. He signed off on all of these medical expenses resulting from this October 5th, 2018 accident. There's essentially no question of fact at this point that provider plaintiff in this suit is entitled to any benefits.
And I don't disagree with that, Judge. As I said, I never received an answer. I never received the motion for summary disposition, but I don't dispute the fact that Mr. Hunter waived his future benefits. With respect to any claim by the insurer against Mr. Hunter, I can't speak to that because I don't represent him. And I never appeared for him in this case.
Sure. I think both parties are in agreement in that regard, and that even as it relates to Mr. Hunter's waiver of various future benefits, et cetera. What I believe Mr. Dowell is saying is that that waiver effectively precludes biomolecular as a summary of Jimmy Hunter, because they were in fact put on notice of the waiver and the settlement, and that therefore biomolecular is precluded from advancing this claim. I believe that that's what Mr. Dowell is saying. Is that correct, ma'am?
Yes, Your Honor. And I think just for the record and to clarify something, we did file the motion for summary disposition in lieu of an answer in this matter. So that might clear up some confusion.
Yeah, it would have helped if that language was put on the motion, but it's okay. I mean,
Sorry.
I take it as a fact when I receive a motion for summary disposition. I take it as a fact that it's being filed in lieu of an answer. But a lot of times, it's just good to just drop it in there at the motion for summary disposition filed in lieu of answer at this time. But I guess the part of the problem here, Mr. Brewer, you said you have not received that motion.
I didn't, Your Honor, but I concede the fact that he waived future benefits in a prior settlement. Now, the
second part of that issue is what the issue is, though. That's that biomolecular is precluded. That's what Ms. Canala is asserting.
Right, and the fact is that biomolecular had a executed assignment of benefits, which would have precluded Mr. Hunter from claiming that bill in his case, which the insurance company also knew that because on their EOBs, they've got a little box that they check that says assignment accepted. And so, the question is, how can Mr. Hunter waive a benefit that he can't claim under covenant, under the Supreme Court opinion in covenant, because he had no standing to make that claim? Now, that's what I would have said had I received the motion for summary disposition.
Well, looks like we gotta set it up, and I'll take the motion under advisement. Let's get a copy to you so that you can respond. I'll set a hearing date. So, because that's where we started at. I would like to see that case in reference to that case, because obviously it gets, the plot thickens, so to speak, because apparently counsel, Mr. Brewer was involved in the actual, in fact, resolution of the case with Mr. Hunter and the settlement of his claims. So, but I'll be glad to take a look at whatever else is involved. So, how soon, Madam Counsel, do you have Mr. Brewer's email address where you could email the copy of the motion for summary disposition?
Your Honor, but I mean, I guess my issue with this is Mr. Hunter and this provider plaintiff are represented by the same exact firms. So I don't see a reason why they wouldn't know the details of the settlement, nor would they carve out a specific exception to biomolecular integration in that settlement.
Well,
Those-
the answer,
Well,
I'm
those
sorry.
bills were there. Those bills were there when the settlement was executed. There was no reason for Mr. Brewer to say he was never on notice or the assignment
no,
of that.
no. That's the whole point.
Hold on a second. Let me do this. Perhaps the two of you need to talk about this, because what's happening is you have an incomplete situation before me. You have the motion filed, and I have no response to the motion. And Mr. Brewer is claiming that he may have something that provides an exception to what would seem to be the order of this case and the rule of this case. If he says he has that, I want to see what that is. Perhaps the two of you can talk, and if there's nothing to go forward on, then there's nothing to go forward on. He's already in a concession, of course, that Mr. Hunter is precluded. The issue becomes whether or not that preclusion is of such a nature by virtue of the agreement that biomolecular is precluded as well. And I know that issue is made more poignant by the fact that Mr. Brewer represented Mr. Hunter and he's not represented biomolecular. But still, all that has to get in front of me. All I have is the plaintiff's defendant's motion for summary disposition. If the defendant is going to respond, then I'd like to see the response, and then I'll make a determination on the motion. But if it might be helpful, it would be good for the two of you to kind of talk about this, because you don't need to be spinning your wheels on something. Certainly some of the issues, issues in the no-fault law, how it applies, settlement issues and issues of assignment of claims and notification of resolutions and what have you. They are imperfectly precise. I know that sounds like an oxymoron, and imperfectly precise. So a lot of times it's very clear that the claims are precluded, future claims are precluded, and other times there seem to be cracks in the floor where you can find a way to come back in. I don't know. All I'm saying is that it's not a problem for me this time. Do you think it'd be useful to have a conversation in a breakout room, Madam Counsel?
I mean, we could. I don't know if Mr. Brewer would still like to see the motion and then respond.
That's what I would like to do, is see the motion and
That's fine.
respond to it. Also, your third-party complaint, if I never got that either.
That's been dismissed.
Oh, has it? Okay.
Okay.
So, Mr. Brewer, you want to talk about this in a breakout room, and you don't think that'd be fruitful?
Well, I know, I think that, once I see the motion, I can deal with it somewhat intelligently and let the court decide.
Got it. Okay, good enough. So again, I'll get this back right away. So if you can email that motion to Mr. Brewer, Mr. Brewer will give you, I'll give you 14 days to file any written response that you'd like to file to the motion. And then I'll set the motion for hearing shortly after that.
Very good.
So we'd be looking, let's get this back in the month of April. So I'm thinking maybe the week of the 18th of April.
1 o'clock, Judge?
Just one moment.
You said April, the week of the 18th?
Yes,
18th.
ma'am.
Oh, you want April the 20th or April 21st?
Or early. That's the 20th. The 20th of April is what I'd be looking at. That would be the hearing date on the motion, and it seems that,
I can do that.
obviously, it's a dispositive motion, if granted, and that would, be the end. If not, then the court will address the case, that. So, Ms. Vidala, I don't know what happened in the transmission of the motion, Dennis, plaintiff said that they have not received the same. I have 2 copies in my file for some reason. So if we get that motion over to him, he has 14 days to respond. And then on the 20th, I'll hear the motion.
What time on the 20th, Judge?
That's going to be at 9:45.
9:45. Very good. Thank you.
Judge, will you allow defense an opportunity to reply to plaintiff's response?
Yes, you want to do it within that time. So right now we're at the, of course, we're at the 24. He has 14 days to respond. That would put in at roughly the 10th of April. So you'd have that other time to respond.
Perfect. Thank you, Judge.
Thank you, Judge.
I'm anxious to see it because the issue doesn't seem incredibly complicated. I just want to see what, I've gone through the motion that has been offered. I just didn't see a response. And the motion, if what is set forth in the motion is true without exception, then obviously the motion should be granted. But, what makes our life interesting as lawyers is that people look for exceptions. So I'll take a look at whatever that might be and we'll see where it goes.
Thank you, Judge.
Thank you, Judge.